The Uniform Commercial Code, or UCC, recognizes that parties contract for performance, not promises. To that end, the UCC provides a process for one party to obtain assurances of performance when reasonable concerns arise about the other party's completion of the deal. In Scott v. Crown, the Colorado Court of Appeals applied this UCC provision to a grain sale contract. In February 1983, Larry Scott contracted to sell 16,000 bushels of wheat to Dennis Crown. The contract called for Scott to be paid 30 days after full performance. On March 1st, prior to completion of the first contract, Scott and Crown signed 2 additional grain sale contracts. Scott delivered the last of the first contract grain on March 13th, making payment due April 13th. In early March, Scott began performance under the second contract. By mid-March, Scott had delivered over half of the wheat due under that agreement. Scott then heard through the grapevine that Crown wasn't the most reputable grain dealer. A Department of Agriculture agent confirmed to Scott that Crown was facing an active non-payment complaint. Based on that information, Scott refused to load the next truck Crown sent for grain. Instead, Scott told the driver that grain deliveries were suspended until he could speak with Crown. On March 23rd, Crown wrote Scott contending that Scott had breached the contract. Crown sent Scott another letter on April 4th, canceling the contracts but agreeing to pay Scott if the wheat was delivered. On April 6th, Scott's attorney wrote Crown demanding immediate payment under both the completed first contract and the partially completed second contract. On April 7th, Crown canceled the 2 unfulfilled contracts. Scott sued Crown, alleging breach of contract for Crown's failure to pay in full under the second contract. The trial court entered judgment on behalf of Scott. Crown appealed to the Colorado Court of Appeals.